Let's make a start. That's 12 o'clock that we're on now. Hello, everybody. Good afternoon. Welcome to the fifth in our series of lunchtime webinars. This one dealing with the topic of IP, intellectual property, protecting your innovative idea with InnoScot Health. Just to let everybody in the audience know, we are recording these, and the recordings will be available via our website and on YouTube after the event. So if you've got any colleagues who may not be able to attend today, you can let them know and they can watch this at their own convenience. So delighted to be joined today by Dr. Julia Darcy, who is a European Chartered Patent Attorney and Director of the fantastic Harrison IP Limited, who have been our IP support for nearly a decade now. What we're going to do during this webinar is really talk a little bit about what IP is, the importance of it. Julie's going to give an overview of some of the main areas of IP and IP protection. And then we're going to do a bit of a fireside chat. I'm not a big fan of the phrase fireside chat, but it's kind of a Q&A where Julie and I will talk about some of the sort of hot topics in IP that are specifically or particularly relevant for people working in the medtech and healthcare arena. So that will include things like employer ownership of IP, confidentiality, and changes due to Brexit as well. And then at the end of that, after about half an hour, 35 minutes, we will have an open Q&A. So we will take questions from the audience. If you have any questions, any comments, please do put them in the chat box, and that's being monitored. And we will try and get through as many of those as we can. And of course, if you have any suggestions for future webinars as well, please do let us know if there's any topics you want us to cover in the autumn and winter this year, and we'll be happy to try and accommodate those. But to kind of kick things off, just with one slide or two slides really, just to give you an idea of why IP is important, I suppose, and just show a very short video, and hopefully you can hear the sound on this just to introduce the topic.
Look at that thing go. It eats grass constantly.
Reminds me of you, only quieter.
Exactly. He stole our idea.
Yeah, what idea?
It mows grass nonstop. We mow grass nonstop. That's our thing. You're gonna hear from our lawyer, pal.
We have a lawyer?
Automower by Husqvarna. It may not be inspired by goats, but it is the goat for a beautifully cut lawn every day without the effort.
I knew it. He said goat. Do you hear that?
Shop now at automower.com.
Okay, so hopefully people could hear the sound on that one. That was much less an advert for Husqvarna mowers, although I'm sure they're a good company, as it was to sort of illustrate the general point that IP and IP protection is all about protecting your idea, protecting it from being stolen. And that's something that Julie will go into in a bit of detail in a minute or two.
Look at that thing go.
You may have read in the news as well recently that there is a case ongoing. I think it's been resolved actually now, which illustrates why IP protection is so important to people in companies and industry. And that's the kind of famous case of M&S versus Swizzles over the Percy Pig sweets. M&S, as you know, take quite a very dim view of people copying their products. They've been to court with, I think, Aldi quite a few times now over the Colin versus Cuthbert Caterpillar cakes. But recently they took Swizzles to court as well and forced them to change the name of their product, which is a very close imitation of M&S's own Percy Pigs. So that's, again, another illustration of why IP matters and why it's important to people. But I'd like to hand over now to Dr. Julia Darcy, who will take us through some of the basics of IP and give us an overview of that and talk about some of the main ways that IP is protected. So I will stop sharing and let Julia share her slides as well.
Start sharing. Oh no, I'm on my laptop and it seems to have an awful lot of security. Robert, could you share? Actually, I wonder if I can do it here. Can you see that?
Yes, that's good. I can see that. It's good.
Thanks, Robert. So just as an overview of what I was intended to talk about today, I wanted to provide an understanding that the development of your ideas, even fairly simple ideas, will generate intellectual property and intellectual assets. To provide you with a bit of context of why IP matters, a framework of knowledge about IP, and a little bit more knowledge about the different types of IP and how diverse they can be. So, first of all, are my slides quite small? I don't know how to get the full screen up.
I think they're fine. Yeah, they're big enough to see the text on the screen. Yeah.
So first of all, why secure IP rights? And as Robert alluded to in his introduction, it's to stop others taking advantage. So like with M&S and the Percy Pigs, they wanted to protect their idea, reward their investment, and stop swizzles using that idea for their own advantage. Securing IP rights means that you can attract investment and you can freely discuss your idea with third parties without them unfairly exploiting your idea, as you'll have a monopoly in the marketplace. And through that, you can build a reputation and create barriers for your competitors. There are many different types of IP, and it's important to remember that one idea or development can be protected by many different types, and each type protects a different aspect. So some will protect the underlying idea, whereas some will only protect the appearance of a product relating to that idea. And using more than one type of IP helps to strengthen your position against that unfair exploitation of unscrupulous third parties. So I wanted to take you through a very brief summary of the different types of IP and what differences they provide. So starting first with patents. Patents are granted for inventions and they protect the idea underneath any development which you make. They're essentially a state-granted monopoly that lasts up to 20 years. And the deal is that you provide disclosure of your invention, and for that, the state grants you exclusivity of that invention in particular territories. And the feeling behind that is that that strong protection rewards and encourages research and innovation. So patents are for inventions, but the inventions can be relatively simple. They should be new ideas that solve problems. And different types of patent inventions in the medtech field include medical devices, drugs, new chemical compounds, methods of manufacturing, and new uses of known compounds, including medical uses. A quick overview of trademarks. Trademarks confront us all the time. So Coca-Cola, the M&S brand, Percy Pigs, they're used to protect a brand. They make your products or services recognizable, and they provide an indicator of the origin of the goods or services. And hopefully that will allow you to provide brand loyalty. And trademarks can potentially last forever. And moving swiftly on to registered designs, they only protect appearance, but they can be a useful tool in your armoury. They're cheaper than patents, they're easy to get granted, and if you have disclosed an invention for whatever reason, accidentally, then they are also associated with a grace period, allowing you to file a registered design after that disclosure. We also have copyright, which comes into subsistence automatically. So as soon as you create a work, you will have generated the copyright in that work. And copyright protects literary, dramatic, musical and artistic works, but that shouldn't be interpreted too narrowly. Computer programs also qualify for copyright protection. The work must be original, so you must have created it yourself, and exhibit a degree of labour, skill or judgment. But the protection provided is quite weak. It only protects against copying. Something else you can think about is just keeping your development secret. And the advantage of this is that no public disclosure of your idea is required, but the protection provided is very weak. It doesn't protect against independent creation by third parties. It only protects against unauthorised disclosure after you've gone to a third party, signed a non-disclosure agreement, and they've then breached that. It's quite helpful to think of patents and confidential know-how in combination. So you could file a patent application, or InnoScot could arrange for one to be filed for you, but you could keep something in reserve and record that confidential know-how of a particularly effective way of using your invention. What I wanted to highlight here is that one product is associated with many different forms of intellectual property. So if we look at the Viagra drug, that's certainly protected by patents. So there'll be patents for the chemical compound itself and for the medical use of that chemical compound. But on top of that, Pfizer have created this blue pill, which is recognisable, and that may be protected by design, registered or unregistered. And they've also got associated trademarks. So the Viagra mark, the Pfizer mark, and that means even once it comes off patent, then they can continue with their brand loyalty through the trademarks. And a similar approach is taken by Zavirax. The active ingredient in Zavirax is now off patent, but people often use the branded product rather than the generic competition because they have brand loyalty to the Zavirax brand. So in summary, when you're thinking about your new development in terms of IP, you have to identify what is it. So consider different aspects of your idea and how they might be protected by different types of IP. Do you own it? Expression of your idea is protected rather than the idea itself normally. And if a contractor creates a copyrighted work, the creator will generally retain ownership unless you have a written agreement. If you're employed, and I think that we'll go into this in a bit more detail during the question and answer section, then your employer may own your IP. We'd also advise inventors to search their development, so to see if there are existing patents, trademarks and designs out there. Those registries are searchable online. And then you have to consider, firstly, where to file. So intellectual property is territorial. And if you don't protect in a country by the relevant deadline, you may not be able to later. And also when to file. there's generally a bit of a balancing act between being able to describe your invention properly and someone else filing an application before you have. So, Robert, I don't know if you want to start the fireside chat type of
Yep.
form now.
I will do that. Yeah, if you could stop sharing your slides and I'll go back to sharing mine. Thank you very much for that, Julia. It's one of the joys of Teams. You're used to using Zoom.
Not used to Teams. How do I stop sharing?
So there should be a little cross in the box in your little window, I think, that says stop sharing.
I think it's all covered up with the recording thing. Sorry about this. Share content. I don't know how to do it. Is that...
Oh, there we go.
No, I don't think so. I think I've got it bigger, if anything. Assume. Okay,
well, it's not an issue. We can leave it for now. So if you just leave the slides up there as you've got them, and we'll just carry on. So yeah, so this part of the webinar then is really just to go into some more detail about certain topics, and they're things that that people have I suppose asked us to discuss, or the things that we have come across, you know, as InnoScot Health, in the past 20 years related to IP that people in NHS boards and sort of medtech seem to want to know about and seem to find important. So I'll start with one point about confidentiality, and you've touched on this a little bit already, but can you just basically outline why is confidentiality so important when somebody has a new or innovative idea, and what can people, say somebody working for the NHS, like a doctor or nurse, what can they do to keep their idea safe when discussing it with colleagues or advisors or those outside of their workplace?
In terms of the importance of confidentiality, it's vital as far as IP goes, especially for patent applications. So any non-confidential disclosure of your invention will mean that you can't apply for a patent application in the UK or Europe. The rules are a bit different in the US. So it's very important that you agree confidentiality before disclosing your invention. That agreement can be made verbally, but it's much better to get it in writing, signed by both parties before the disclosure takes place. And that's particularly important if you're disclosing to someone outside your organisation. So if it's your line manager, say, then an implied confidentiality could come into existence quite easily. But if you go to a third party outside the NHS, then it would be much more difficult to prove. So we would basically strongly advise you not to make any non-confidential disclosure before filing a patent application, or at least reviewing to see if it's suitable for a patent application. And if it's required to discuss with a third party, we'd advise that you get a written non-disclosure agreement.
Great, thank you. And those are all things that, of course, at InnoScot we can help with if you work for the NHS. So just to be clear, then, Julia, say suppose I'm like a midwife working for NHS Grampian, and I want to talk to my clinical lead or my line manager about my idea. That's generally fine to do without any sort of agreement in place. But if I wanted to, say, speak to a university about it or a company, then I need to do something to protect the idea.
Yes, exactly. Yeah. So when you're talking to your line manager, there's an implied confidence apparent there, but any third party, such as a university, you should get an NDA in place before disclosing.
Great, thank you. So turning to the subject of know-how now, and again, I think you briefly mentioned this as well. When we develop and commercialise IP and innovations on behalf of NHS Scotland, very typically, we would license IP rights to a third party, to a manufacturer, distributor, and that's very often a patent. But increasingly, we find that a lot of the innovations that come to us contain a fair amount of know-how. So the important stuff that's in people's heads about how a process or a system or an innovation works. Is it possible to protect know-how? And if so, how can you license that? How can you grant rights to somebody's know-how to a company?
You can protect it through confidentiality, and it's certainly possible to license confidential information, or at least, well, including information that isn't freely available. So even if it isn't strictly secret, if it's not freely available, it's likely you can include that in a license. Normally you'd tie it in with some other form of IP. So you'd provide a patent application license and refer to the know-how as well, or a copyright license at a push. The difficulty of licensing know-how is it's difficult to define, because often it's in the inventor's heads and it's the best way of practicing the invention or the development, but it isn't necessarily even written down. So that can prove difficult. But yeah, know-how can be very valuable. And if it's licensed, that can sometimes be the most valuable aspect of a development. Let me just see if one thing to be aware of is if the know-how information comes into the licensee's excuse me, licensee's possession through other means, then the licensee may be free to use that information regardless of the license.
Okay, so that's another good reason to have a confidentiality agreement really in place to cover off discussions. Is it a good idea then to try and, for an innovator, to try and write down, if they can, what the know-how is and do it in bullet points or a page, or is that not a good idea?
No, it's a good idea, yeah. I mean, it helps summarize what they know, and that can make it easier to assess whether any other types of IP might be usable for the invention, because quite often an inventor will consider their development to be obvious because they're working in that field day in, day out. But to a patent examiner or a design examiner, then it won't appear obvious, and we could get stronger protection for that. So yeah, certainly when you come up with a development, it's very useful to summarize it in writing, to date that, and to possibly keep those dated pages with a third party, such as a lawyer or a patent attorney or InnoScot Health. So there's an independent record of what was invented when and who invented it.
Okay, and presumably if that's signed and dated, that would be valid if it ever was tested in the court of law or for, by a patent examiner or whatever. That would be, if it's signed and dated and kept somewhere, that's enough.
Yes, if it's kept by an independent third party, I think that will be enough, such as a solicitor or yourself or a patent attorney. If you just keep it yourself, there's no particular evidence that that date is accurate.
Okay, thank you. We've had a few webinars over the past few months. In particular, we had one on regulatory affairs a month or two ago, which mentioned some of the changes that have come into the regulatory world in relation to Brexit. I wonder if you could tell us a little bit about how the IP world and the IP protection world has changed in relation to Brexit, and is there anything we need to be aware of this year, next year, as as Brexit is kind of unfolding?
The developments in terms of IP have happened already with regard to Brexit. So trademarks and registered designs used to be EU, well, they still are EU-wide, and that means that with the UK coming out of the EU, then EU trademark and registered designs were split into separate UK and EU rights. The patent regime hasn't changed a great deal. That's protected by a non-EU convention, the European Patent Convention, which includes lots of countries which aren't in the EU, like Turkey, Norway. One difference in terms of patents is that a new patent system has recently come into effect, the Unitary Patent Convention. That is an EU-wide convention, but you have to opt in, and lots of EU states haven't opted in. It came into effect the 1st of April. The UK was going to be part of that, but since Brexit, it hasn't been allowed. So that means that we can act before the Unified Patent Court, but the UK isn't a member of the convention itself. Marketing authorization, there's a new UK body. I should think that your regulatory talk covered that. And supplementary protection certificates. So that's an extension of patent protection for pharmaceutical inventions. That's changed from an EU-wide right to a UK right. But yeah, the changes have essentially come into effect, and it mainly affected trademarks and designs rather than patents.
Okay, thank you. So with the unitary patent system then, so imagine, if we had a European patent and it was validated in, I don't know, UK, France, Germany, and Italy, and somebody in Italy wanted to contest it or try and have it revoked. Does the unitary system change the way they do that, or?
Yeah, it would. So the Unified Patent Court, which is the court of the Unitary Patent Convention, covers all EU states. Even if you don't use the Unitary Patent Convention, if you have a straight Italian patent, that would fall under the remit of the Unified Patent Court unless you had already opted out that EU patent, so French, German, Italian, from the jurisdiction of the court. And we would strongly advise you to opt out your national rights from that jurisdiction, because the effect of it is that rather than the 9-month opposition period, which you normally get with European patent rights, a third party can contest the validity of your European patent rights across all EU states in one action for the lifetime of the patent. So it's important to consider opting out your European patents from the jurisdiction of the UPC if you're not interested in taking advantage of the unitary patent system.
Okay, and it's fair to say this, because this is a brand new system, it hasn't actually been tested yet. Or has anybody actually, do you know if anyone's tried to test this in a court of law? Or is it still too new?
Some validity actions have already been filed right from the first day it came into effect. But those court cases haven't yet been decided. So it's a new and untested court. It covers all EU states, even for national rights, not just for unitary patent rights. And I think the consensus opinion at the moment is it needs further testing, so to opt out. And it's certainly not proving that popular yet with our clients.
Good to know, thank you. Touch on something else now as well. This is the sometimes sort of thorny and problematic issue of who actually owns your IP rights when you invent or create something. We've certainly come across situations where it's very difficult for innovators to know who owns the idea within the NHS. Is it themselves? Is it their employer? Is it someone else? Could you clarify, how that works and how it perhaps how it works for, I don't know, say a typical nurse or physician or midwife working in the NHS?
So the general rule is that an invention will be owned by the inventor unless they're employed and the creation of the invention occurred during their routine tasks or tasks specifically assigned to them, and an invention could reasonably be expected to come out of those tasks. I know an issue in the NHS is that lots of people are actually employed by charities or third parties, but work within NHS premises, that does complicate things. So that's one thing to consider. If you've been given time during your working day to work on the creation of the invention, then it's likely that your employer will own those rights, whether that's the charity or the NHS. If you've created the invention in your own time, it's likely the inventor will own their rights. The other, it's a two-pronged system. The other prong to the system is that if you have a special duty to further the interests of your employer, then it's likely more inventions that you invent will be owned by your employer. So if you're very high up within an organisation, it may be that your inventions will all be owned by your employer. But in the normal case, the rule of thumb is if you've been given time and resources to work on the creation of the invention during your working day, then your employer is likely to own your invention. Whereas if you've done it in your own time, it's likely to be owned by you.
Okay, I guess the problem we have quite often then is, I don't know, say take an example of a midwife again. A midwife would say, well, I'm not employed, to do research necessarily or to make inventions. I'm employed to help deliver children and babies. So I've invented something. I wasn't specifically told by my employer to do it, and that's the kind of issue that we sometimes struggle with, I think, and that the NHS struggles with. Who would then own the invention in that case, with that situation?
It's likely to be the midwife. If she's come up or he's come up with the idea himself, even if it relates to midwifery, then, like you say, they're not expected to invent. So it's outside their routine duties. If they came up with a kind of concept, but the actual invention was in pinning down that concept and developing a product, and they were given time during their working day to develop that product, it may be that the invention belongs to their employer. But it's not that clear cut, and really you need to get advice if there's any uncertainty at all.
Okay. Would it be better for people's employment contracts to have something in about IP ownership, or is that not really enforceable or not practical?
It wouldn't be enforceable. I understand that InnoScot you provide help on the basis and the agreement with the inventor that help would be provided if the invention is owned by the NHS rather than an independent. So at that stage, I suppose the ownership of the invention would be considered in depth.
Okay. Last question then before we sort of move to general questions for the audience. As I'm sure you know, machine learning, AI are quite new areas of innovation, and we're seeing a lot of things come through, a lot of innovations, inventions related to machine learning and AI in medtech. Is it possible to protect the IP contained within an AI or a machine learning type innovation, and how would you do that, or what ways could you do that?
Yeah, it's certainly possible to protect AI through patents. So there's an exemption to patentability for computer software, but that exemption is interpreted very narrowly. And in the UK and Europe, if a software invention solves a technical problem, then it's likely that we could get patent protection for that. In addition, it would be protected automatically through copyright. So the algorithms behind the AI will be protected by copyright, and it's likely that we could file a patent application if the invention provides a technical effect. So it seems to me that there's so much money going into AI at the moment that the patent examiners are likely to recognise that, protect that innovation, and they're likely to become a bit more lax when it comes to objecting to the patentability software inventions of that kind.
Okay, thank you very much. Well, thank you very much for that. We have a few questions from the audience. We actually went out before today and asked if people would like to pre-submit questions. So I have a few to go through. I'll kick off with one. Somebody's asked, is the contractual position on IP consistent across NHS Scotland? And I'll field that one first. Maybe Julia, please come in. I guess the way that IP is handled across NHS Scotland, it's set at a policy level by the CSO, the Chief Scientist's Office, but within NHS Scotland itself, across the 14 regional boards and the 6 or 7 special boards, each board has an IP policy which determines how IP is to be protected and exploited. Most cases, it does mention InnoScot Health and says, refer to or discuss with InnoScot Health. The differences between the policies are mainly to do with the fact that the way innovators or inventors are rewarded from any commercialization of IP differs across the boards. So I think all the boards specify in their IP policy that if you invent something and the IP belongs to the board and it's successfully commercialized as the named inventor, you will get a share of any royalties from the sale of that product, but the amount you will get will differ depending which board you work for, whether you work for the ambulance service or NHS Lothian or Grampian or whatever. So that does differ there. Julie, is there anything you wanted to add to that, or?
Well, in my experience, the IP policies seem pretty consistent across the NHS. I haven't reviewed them in detail, but certainly they're a lot more generous than they need to be through law. So I think the NHS does provide a good return for employees' inventions.
Okay. We've had one submitted actually into the chat, which was pre-submitted as well. So I'll read this out, and I think possibly it's one for Julia as well. Somebody said, hi, with colleagues in NHS, we've developed a novel specialist psychological therapy group program for treatment of mental health difficulties. We're currently gathering evidence of efficacy, and in advance of cascading, rolling out more widely to NHS boards, we want to consider the IP content, thinking copyright license. Would this involve any further action? We appreciate the IP is likely to be owned by a specific health board employer. Anything there, Julia? I mean, what do they need to do to protect the IP in that kind of sort of therapy program or educational program?
I think it probably would be copyright in terms of the materials provided and the instructions provided across the NHS. It's tempting with something like that to consider patent protection, but I think it would be excluded on the basis of a method of doing business. I know it's not a business, but it's a kind of decision tree of where, well, I'd have to review it in more detail, but assuming it's kind of do this if this happens, I think it would be more copyright protection, as you say.
Okay. Well, what we'll do, we'll pick up with the person that submitted that question after today, and do more of an assessment on that. Have a chat with them. One other question that's come in then is, what additional protections, whether it's contractual terms or otherwise, would you suggest are needed if parties want to jointly file a patent?
We would generally tend to discourage joint filing of a patent application because it can get quite messy. If you do want to jointly file a patent application, I'd advise that you come to a written agreement about costs and decisions. So who makes the decision on the territory, how the patent application is prosecuted. If no agreement is made, then you can find yourself in the position where one party has paid for all the costs, but the IP still, or the patent application remains jointly owned, which isn't fair. In the US as well, then each co-owner can do their own thing. So it can mean that if you have parties A and B, party A can go off, agree a license with a third party, not provide any of the revenue to party B. So that situation is, well, it can clearly lead to unfairness.
Yeah. Okay, thank you for that. I think we've probably got time for maybe just one more question before we wrap up. Julia, as you probably know, we NHS boards are using a lot of SBRI type competitions now to sort of go out to industry with a very specific, narrow, focused problem that they want industry to solve, and they invite companies to compete, and they have an application process. One of the questions in the application form for companies relates to freedom to operate, and I think, having reviewed some of these, there appears to be a bit of misunderstanding about what freedom to operate actually means, and and protecting your IP. What rights does that give you? So could you tell us a little bit about what is freedom to operate really in an IP sense, and what does having a granted patent actually enable you to do in relation to that?
In terms of having a granted patent, a patent provides a negative right rather than a positive right. So it doesn't provide you with any rights to use your invention. It only provides you with rights to prevent others from using your invention. Before you launch any product, we'd advise that freedom to operate is considered. That would result in reviewing the patent databases to see if there were any granted patents or pending patent applications in the area you intended to commercialise your invention, and whether you would be likely to fall into the scope of the claims of any third-party patents. It can be quite expensive, and it's limited by territory. So if you were only interested in the UK, we would do a UK-only freedom to operate search, but the UK would be protected by European patent applications as well. So even in the UK, you have issues of translation and trying to guess what granted rights would come from pending applications. So some companies tend to file a very broad patent application on the understanding that they would only get granted rights, which were very narrow. Yeah, it's a bit of a minefield, freedom to operate, but you really need to do it before launching any product.
Okay, so you would probably advise a company in that situation to actually approach you to get a proper FTO opinion.
Yes,
approach
a patent search company. They can provide the results, but not the analysis. But if a company wants to reduce costs, they could go through those results and see if anything jumped out at them.
Okay, thank you. We'll do one last question because we're at 12:43. This question's come in. Someone saying, as part of a former university project that involved collaboration between a person within the NHS and a group of students, the main IP has been produced by the student, and the only role of the NHS was to provide a facility to meet the person. So the only input from the NHS staff was feedback on this. What rights would the NHS have on the final medical device, given that there was no hard contract that specified the NHS would own the outcome? If that makes sense.
Well, I'd have to review the specific development, but on the basis that the NHS just facilitated the meeting of people, then it doesn't sound like there'd be any NHS inventor within that collaboration. So to be an inventor, you have to contribute to the inventive concept underlying the device or development. And if there was no NHS inventor, in the absence of any agreement regarding ownership, the student would own that IP. Okay,
thank you. Well, we're just approaching 12:45, and I think that's all the questions. So it just remains for me to say a huge thank you to Julia Darcy for providing your expertise and advice today. That's been enormously appreciated. I hope the audience, I hope you all found it useful and interesting. As I say, we've recorded this so you can watch it again if you need to. We're taking a bit of a break over the summer now in terms of our webinars, but we will be back around September. We have a webinar on the theme of clinical entrepreneurs. So if you are one or want to be one, or you want to know more about how clinical entrepreneurs are supported and developed within the NHS, then do attend that. And we'll be confirming the date of that shortly, along with future content. But thank you again to Julia. Thank you all for attending today, and I wish you a good afternoon.
Thank you.